Hello, everyone, and welcome to the fourth edition of Soundbites. My name is Stephen Reagan, and I'm the Principal Privacy Consultant at Rangu. Basically, with these Soundbites, I like to discuss a bit about some recent events in privacy and data protection. So I'm going to talk about three things in particular today. The first being building consumer trust by making privacy and data protection a part of your organizational strategy, as well as your marketing strategy. And I'm going to take a little bit of a deeper dive on privacy by design. And then I'm going to turn to an interesting case that came out of France recently that has implications for how organizations work with American subsidiaries in the aftermath of the Schrems II decision. And then with the emphasis on America, I'm gonna stay there and focus on a report that was delivered at the 46th session of the Human Rights Council between February 22nd and March 19th that discusses American surveillance practices. So privacy by design is important principally because it's included in the GDPR under Article 25. But data protection and privacy by design and by default has actually quite a long history. That was so this idea was first introduced in the 1970s and was incorporated in the European Data Protection Directive in the 1990s. This has continued to develop and has been then promulgated in the GDPR, in particular, again under Article 25. So now, what exactly does the article say? The article creates the requirement that controllers implement appropriate technical and organizational measures and necessary safeguards to protect the rights and freedoms of data subjects. So the big emphasis with this article and with privacy by design is that you think about the safeguards and you take these into consideration before you implement processing activities. So oftentimes we are thinking about things post hoc after you've collected the data and have done some type of processing on the data and recording that in your processing activities. But this is really an analysis that needs to come before any of that processing takes place. And so some of the language that I've used it certainly draws from the data protection impact assessments and that kind of risk analysis that's covered under Article 35. So the principles of privacy by design were formulated and expressed really well in the seminal article by Anne Cavoukian in 2016. And there are 7 foundational principles that she mentions. And they are: the first one is to be proactive and not reactive, preventative and not remedial. So again, this wants to take an anticipatory approach to privacy and data protection and kind of anticipate some of those issues that might arise. The second principle is privacy as a default setting. So often when we think about privacy and data protection, it's about giving rights to individuals. You think about those articles 15 to 22 that gives the data subject certain rights, like right to access the data, the right to have data corrected, or for example, the right to data portability. With this principle, privacy as the default setting really wants to emphasize is that privacy is protected even if the individual does nothing. So that kind of removes this burden from the individual to take affirmative steps to protect their privacy rather than protecting privacy from that initial stage. So the third principle is privacy embedded into design. That means that privacy would be an essential component of the core functionality being delivered by an organization. The fourth principle talks a bit more about functionality and tries to conceive of the idea as a positive sum approach rather than a zero sum approach. So this thinks about conditions of like a win-win and tries to articulate these or shed light on these false dichotomies that occasionally arise, and thinking about that as like privacy versus security or privacy versus business objectives. And this is really about reformulating how we think about privacy and how it can inform what we do, and ultimately how that can be a good for the end users and consumers, making your organization more trustworthy and thus more likely to be selected, or for the user to give consent in the case of processing data. And as we move to an increasingly interconnected world where we generate so much data, this is going to be a really big competitive advantage for organizations. They can convey that they're a trustworthy organization, that we shouldn't have any fear about giving our data to them. So then the fifth principle talks about end-to-end security, really managing that full life cycle of the data, and that is secured throughout the entire process, and then destroyed at the end of the process in a timely fashion. So thinking again about ideas like retention limitations in the GDPR. And on that topic of building trust, we want to think about the sixth principle thinks about visibility and transparency, really keeping it open and assuring all stakeholders that operations operate according to the stated promises of the organization. When we think about those privacy policies that dictate how organizations use data and what it's collected for, this visibility and this transparency really ensures that those principles are being adhered to. And again, this visibility and this transparency really is a generator of trust for data subjects. And then finally, the last principle is respect for user privacy. Respect for user privacy, keeping it user-centric and really user-focused. And this goes along those lines of making things easier for the data subject. Again, at the beginning, we want to emphasize privacy by design, privacy by default, so the data subjects don't have to take affirmative steps. And in the current environment, it really is that we provide the data subjects certain rights in order to take agency over their information online. And so if we're going to take that approach, at least make it easy for the data subjects to facilitate those access requests. So privacy by design, again, has a really long and really interesting history that stretches back over 50 years. And we see it implemented now in the language of the GDPR. And so focusing a little bit on that particular language, Article 25 requires organizations consider the state of the art of the technology, the cost of implementation, and the nature, scope, and context and purpose of the processing, as well as including a risk analysis of the likely harms to the rights and freedoms of the individuals. So again, with this last bit about doing this risk analysis, really drawing from what we've learned from conducting data protection impact assessments and weighing those legitimate business interests on the one hand against the threats to those rights and freedoms of the data subject on the other hand, and also considering factors for mitigation in the case of a data breach, for instance. So focusing a little bit more on the language of Article 25, the criteria state-of-the-art requires controllers stay up-to-date on technological progress. This, of course, is because technology evolves really quickly, as well as those plug holes and antivirus software, for example, as well as security updates. We get those constantly, and those are for good reason, because the technology has evolved, and therefore the defenses have to evolve with them. The criteria for the cost of implementation requires that controllers consider the cost and resources required for effective implementation and continued maintenance of the data protection principles. And then finally, data protection by default means that, again, this personal data is collected and used for things and is limited to what is strictly necessary for specific purposes. Again, the default setting should prioritize the privacy of personal information without the data subject having to do anything. We all know about the constant stream of cookie consent forms that we have to adhere to every time we go to a new website. It would really be easier for us all if these third-party cookies were not collected in the first place. And of course, ad tech people will be very upset at me for saying that, but it does really seem to be going that way, at least with regards to third-party cookies, as Apple and Google phases those out. But again, this emphasis on implementing these TOMs, these technical and organizational measures, really as a stopgap for privacy and data protection. And when we think about it at that level of, at the moment of design, really taking into account privacy and data protection, as the GDPR requires, really emphasizes that at the early stages of planning our services and what products we'll be providing, and that's really kind of great and impressive to see Europe taking this privacy forward approach. A really interesting case that came out of France. The case was decided on March 12th, 2021, by France's highest administrative court, basically ruling that personal data on a platform managed by Doctolib and hosted by Amazon Web Services had sufficient safeguards in place to manage access requests from the U.S. authorities. So this was a really interesting case on the back of the Schrems II decision in July of 2020. That decision invalidated the Privacy Shield, the legal transfer mechanism for sending data from the EU to the United States. So this is a really interesting kind of gray area in the law, because the data was not transferred from the EU to the United States, but was hosted in Europe. The key issue was that Doctolib hosted its data on a subsidiary of Amazon Web Services, of course, an American organization. The AWS services they used was called AWS Searle, and that data was hosted in Luxembourg. And the plaintiffs basically argued that the processor, in this case Amazon, was a company bound by U.S. law, and therefore the risk of access by U.S. authorities was incompatible with the requirements of GDPR and Schrems II. So in that Schrems II decision, one of the reasons for invalidating the Privacy Shield was the U.S. surveillance apparatus was considered not necessary or proportional. It went beyond this scope, and thus created difficulties and privacy risks for European subjects and European citizens. So again, this was a really, really interesting case, and I'll give a little bit of a factual background. Doctolib is a leading e-health service company in Europe, and basically when online users wanted to get a vaccine against COVID, they could make an appointment on the Doctolib platform. That data was then stored on services, cloud services provided by AWS Searle, again based in Luxembourg. So what did the court say? The court, in essence, found firstly that there was the factual issue that there were no data transfers from the EU to the US, but they nevertheless concluded that there was a risk of access by US authorities, as the EU-based processor was a subsidiary of an American company. However, the court considered then these additional safeguards that could be put into place that would satisfy this decision of Schrems II. And those safeguards were twofold. There were legal safeguards and technical safeguards. So in concluding in favor of Doctolib and their continued use of the AWS service, the court found that the safeguards were sufficient, and the legal safeguards were contractual provisions that AWS Searle guaranteed to Doctolib that it would challenge any general access request by public authorities. Now, what form that takes wasn't delved into in too much detail, but overarching, get these guarantees and get them into your contracts that say that these processors will challenge these general access requests by public authorities. So on the one hand, organizations don't have to be really that worried about these access requests. They don't happen that often, but getting that guarantee that the processors will challenge those requests was seen as really important for the court in this case. And the second big finding, or the second big safeguard that the court noted, were the technical safeguards. The court noted that the data hosted by AWS Searle was encrypted, and the key was held by a third party in France, not by AWS. So again, these two safeguards, the court decided, were sufficient to satisfy those requirements under Schrems II. And again, this was a really interesting case because while there was no data transfers from the EU to the US, there was this open question of could European organizations work with American subsidiaries, even when the subsidiaries were located in Europe. Again, as we await these negotiations between the US and the EU on an update to the Privacy Shield, it's really important for organizations to keep in mind these additional safeguards. And so, again, these legal and technical ones, those standard contractual clauses, those binding corporate rules, and then the Article 49 derogations, as organizations look to solve some of these business challenges in the near future around data transfers and working with American subsidiaries. Now I'm going to turn to this report of the Special Rapporteur on the right to privacy that was delivered at the 46th session of the Human Rights Council between February 22nd and March 19th of 2021. This is a really kind of timely and interesting report. The mandate for the Special Rapporteur was created in the wake of the Snowden revelations, so it really explores the surveillance apparatus in America, and kind of surprisingly, it doesn't completely condemn the American surveillance apparatus, and actually in effect kind of turns it back on Europe in some capacity. So I will quote a bit from the report and the findings. Again, because it's really topical considering the negotiations that are ongoing right now between the EU and the US on an update to the Privacy Shield that was invalidated in part really heavily because of the American surveillance apparatus. And again, so quoting a bit some interesting findings. In one instance, the Special Rapporteur notes that the United States is, in fact, one of the top 10 or 20 countries in the world when it comes to the extent to which the right to privacy is protected in the realm of surveillance. And in fact, it goes on to say that let it be unequivocally stated that the United States has more safeguards for privacy in matters of surveillance than the vast majority, around 20 of the 27 European Union member states. So in some sense, in his report on America, the Special Rapporteur really kind of turns it back on Europe and articulates this hypocrisy that's often echoed in the United States, that the U.S. is being held to a standard that on national security and issues of surveillance that is not what is the case in Europe, and if Europe's trying to establish this particular standard, these suitable safeguards and essential equivalence with the GDPR. Well, if that level is lower in Europe than it is in the United States, then certainly in this case, the United States should be adequate. That's, of course, not the case. That wasn't the decision of the Court of Justice of the European Union in that Schrems II decision. But again, so this is a really interesting report. The Special Rapporteur does offer a bit of a historical overview of privacy in America. Discusses a bit about what some academics, the debate on what exactly privacy means, as well as offering some recommendations to the American intelligence organizations, to the surveillance apparatus in America, to kind of move it forward and bring it in line with the systems of Europe and the United Nations. And in particular, the Special Rapporteur is emphasizing the test of necessity and proportionality for data collection, and this being implemented into the American legal system, because as it is at this moment, this is not a part of the formula in the calculation, in this calculation of what can be surveyed, what can be collected, that really kind of resulted in this really pervasive surveillance apparatus that Snowden revealed back in 2012. And again, this mandate for the Special Rapporteur was actually created in the wake of those revelations. And he spent 5 years observing in the United States the United States surveillance activities. So again, touching really briefly on the historical overview of privacy in America, there's actually no right to privacy embedded in the United States Constitution, but it's often been read into the First and Fourth Amendments, in particular the Fourth Amendment's protections against unreasonable searches and seizures. So what does privacy even mean? Privacy in America can really be collected under 6 general headings. The first of those being the right to be let alone. Now, this idea was developed in a very famous law review article at the turn of the 20th century, written by Samuel Warren and Louis Brandeis. Then the second heading is the limited access to the self. So in particular, being able to shield oneself from unwanted access by others. The third heading or principle is secrecy, so that capacity to conceal certain information from others, which leads into the fourth principle, control over personal information. So really the ability to exercise control over information about yourself. The fifth heading, personhood, the protection of one's personality, individuality, and dignity. And then finally, the sixth heading, intimacy, which is really control over or limited access to one's intimate relationships or aspects of life. So the American approach to privacy and thinking about what privacy is really encapsulates these 6 principles. And the laws that govern surveillance in the United States, there are actually a number of them. So you have the Privacy Rights Act of 1974, the Electronic Communications Privacy Act, and the Wiretapping Act embedded within it, and the Stored Communications Act. So these really govern electronic surveillance of U.S. Citizens. And so there's another set of laws that govern foreign intelligence surveillance activity called the Foreign Intelligence Surveillance Act. And under the Wiretap Act and under the Foreign Intelligence Surveillance Act, I'll just call it FISA from here on out, these require reporting on the number of applications to conduct wiretaps or intercept wire, oral, or electronic communications. And so in 2019, under the Wiretap Act, there were a little over 3,000 applications. About 1,800 came from the states, with the other 1,400 from the federal government. The concentration of the applications at the state level focused on 6 states, in particular New York, California, Nevada, Colorado, North Carolina, and Philadelphia. This accounted for about 80% of the applications, and 50% of those came from California and New York. And there are reports of the applications and how many there were that goes back to about 1997. Whereas the Wiretap Act governs surveillance of Americans, U.S. citizens, U.S. persons. FISA has a similar provision for those applications to surveil foreign individuals. In 2016, the FISC approved a little under 1,800 applications. The Federal Intelligence Surveillance Court received 1,700 applications, approved about 1,400 of those, approved another 400 that were modified, denied 26 in part, and in full denied 9. So it really, stretches one's imagination to wonder what was being requested in those 9 cases. In a footnote, the special rapporteur noted concern that there is this potential that tens of millions of Americans and non-Americans are placed under surveillance as a result of these applications, which of course, raises some real Orwellian concerns. So now turning to the recommendations for reforming in part the American surveillance system, really a main one was embedding these tests of necessity and proportionality for what information is collected and how pervasive the data collection and information collection programs are. So the Special Rapporteur recommends a gradual overhaul of privacy laws, really with a special focus on simplification and an increase in both safeguards and remedies. He did note that since the Snowden revelations, the United States has really changed things. in some sense. I mean, not majorly. There are still a lot of concerns, and of course we saw that most recently articulated by the Court of Justice in the Schrems II decision. So when the government makes these applications to the Federal Intelligence Surveillance Court or at the state court level, so again, at least at the level of federal intelligence, and these applications are going to a specialized court, the Federal Intelligence Surveillance Court, whereas those applications at the state level are going to state courts that aren't necessarily adequately prepared to handle these requests. So yeah, the special rapporteur noted in particular that one of the largest concerns arose from the current system that permits warrantless searches by authorizing them to be carried out against a system of rules which are reviewed annually. This is basically justified by the argument that the government would have to seek individual court orders based on a finding of probable cause. This was really expensive in terms of time and resources. The government couldn't occasionally meet this probable cause standard, which it argues was designed to protect U.S. persons and persons in the U.S. So again, we have this arising of this dichotomy of privacy versus security that isn't necessarily it's not really a fair analysis. In some sense, in order to have privacy, you have to have data security, and of course this is kind of altering that perspective on security, whereas it's being used in this case for the protection of the American people. But the special rapporteur notes later on, of course, that often terrorist attacks are homegrown, unfortunately. But this really cuts against that argument that it places a large emphasis on the surveillance of foreign individuals. So the special rapporteur strongly recommends that the existing legal framework created by FISA be reinforced, in particular by expanding the strength of the Federal Intelligence Surveillance Court, giving them the resources necessary and the adequate number of independent judges to make these probable cause determinations. Then training those judges adequately in matters of technology law and security science, really creating a specialized branch of the court to handle these surveillance issues and issues around technology. And finally, he recommends, again, increasing the required resources in the intelligence communities to equip the Federal Intelligence Surveillance Court and the intelligence community for this task of handling, in particular, these surveillance requests before they happen, rather than doing it after, doing a post hoc justification that these surveillance activities were necessary. Special rapporteur in particular goes on to do a bit of criticism of the previous administration, in particular citing an executive order by President Trump that was titled Enhancing Public Safety in the Interior of the United States, which directs federal agencies to ensure that their privacy policies exclude persons who are not United States citizens or lawful permanent residents from the protections under the Privacy Act regarding personally identifiable information. The special rapporteur commented that the issue is really a matter of risk and doing a risk and considering the risk potential of the threat that an individual poses, regardless of their nationality or residence. Basically, the question should be: is somebody at risk or not? And their nationality or place of residence isn't really relevant in that calculation. Again, noting that most terrorists, unfortunately, are homegrown. And then the special rapporteur went on to criticize a letter that was co-signed by the former Attorney General William Barr and the Acting Secretary of Homeland Security, requested Facebook not to proceed with its plan to implement end-to-end encryption across its messaging services, basically without including a means for lawful access to the content of communications. Again, justified by the need to protect United States citizens. Embedding the necessity and proportionality as a criteria when giving authorization to surveillance activities, and then limiting that bulk processing of data that really formed the crux of those Snowden revelations. And then, so I'll just conclude with a last quote, to the United Nations. It's going to be a bit high-minded, but the quote is, "It is time for the government of the United States to emphasize that people are citizens first and consumers second. People enjoy a right to privacy, irrespective of what, when, why, and how they consume." So this is really taking aim at the recent state legislation movements to protect privacy, in particular emphasizing the individual as consumer. Really taking aim, the Special Rapporteur taking aim at this focus on the individual as consumer, and hoping that the United States, whenever they come around to getting their piece of federal privacy legislation, will look at individuals beyond this scope of just being a consumer, and rather focus on that individual right, that human right to privacy. So thanks for tuning in. I hope you enjoyed it. I hope you learned a little bit about American surveillance law, what's going on around the Schrems II decision, in particular that case out of France, and then thinking about some considerations for building consumer trust by implementing these important principles of privacy by design and privacy by default. So until next time, thanks. Bye.